Hi, everyone. Thanks for joining us today for this webinar on key developments impacting corporate executives in white-collar investigations. My name is Lauren Briggerman, and I'm a member in Miller and Chevalier's white-collar practice.
And my name is Katherine Pappas, and I'm counsel in Miller's white-collar practice. So today we're going to get started with a little bit of courthouse news. Something that's front of mind for everybody is the pandemic. And despite the onset of COVID-19 and the impact it has had on court operations around the country, we are now actually starting to see some activity in sentencings and in indictments impacting corporate executives in recent months. And as the virus has spread, including among jails, we've seen a lot of motions practice among white-collar defendants seeking to move to home confinement. And many of those requests have been granted. And although it's unclear when operations are really going to return to normal, we are seeing investigations, charges, and sentencings move forward. So Lauren, what else are we covering today?
So today, and we can go to the agenda slide now. So we're going to give you an update on new and expanding investigations and how those impact executives. We're going to talk about noteworthy sentencings, and we're going to get the latest out of the Southern District in New York. In particular, the U.S. Attorney's Office for the Southern District of New York has suffered some significant reputational setbacks in recent months as a result of failing to provide exculpatory evidence to defendants and also engaging in retaliatory and political tactics. So we're going to talk a little bit about that. But before we launch into our program today, let's get first a sense of how COVID-19 is affecting our courts and criminal cases across the country. Katherine, what are you hearing about courthouses and how they're operating today?
Sure. So as I noted up top, we are starting to see some movement. A lot of courthouses really shuttered in March when the pandemic took hold, but we're starting to see them all move forward into new phases of operation. So taking a snapshot of courthouses, especially federal courthouses across the country, we see a lot of courts moving things to remote proceedings, whether that's via phone or via video. But we're also starting to see in-person things like grand juries and petit juries being seated, and courts trying to move towards more normal operations to get things moving again. But as each court, each jurisdiction, each state has their own rules, we're really seeing kind of a patchwork of different approaches across the country. So I thought we would start by talking about a few courthouses that are resuming more open operations than others. So kind of turning first to the Northern District of Illinois, Chicago. The chief judge there has been issuing iterative orders over time as courthouse operations have changed, and her next order should actually come out middle of November or earlier than that. So we may see a shift, but at least for now, the court is open and they're doing in-person jury trials. Just last month, the government secured a conviction in a white-collar case, U.S. v. Vorley, that had a seated in-person jury. But I would note that operations are not happening without hiccups. The jury in that case started with 14 individuals, but by the time of deliberation, they were at 11 because 3 people had to be removed due to potential COVID exposure. And if you go to the courthouse website even today, you can see just last week, there were employees and visitors to the courthouse who wound up testing positive. And the chief judge has notified everybody of that fact. So it remains to be seen if any alterations to their operations are in the future, or if kind of just notifications about exposure are going to become the new normal there. Turning to New York, both SDNY and EDNY have moved to a phase of their reopening where they can also start having jury trials. They have specially designated courtrooms. They have safety precautions in place, everything from social distancing to mask wearing to temperature checks when you come in. But because of the social distancing and the amount of space that you need to really have that many people in a courtroom, but also at least 6 feet apart, their operations are in specially designated courtrooms. And so, for example, in the Eastern District of New York, they're only seating 1 jury a day because of space limitations. Just this week, on Monday, the Southern District of New York had its first white-collar trial kickoff. They sat a jury within a day and opening statements started. That's a securities fraud case against some former executives at a biopharmaceutical company. So that's moving forward, and we'll see how it turns out. Hopefully there's a less exposure there than there was in Chicago. I think it's worth noting one very recent outcome in a Colorado state court. Just yesterday, a judge held a public defender in contempt when he appeared for the start of a trial via video. So the trial was supposed to kick off yesterday. The public defender said, in light of rising case numbers in the area and public health data, that he was going to appear via video. And he pointed to a court order saying that all criminal proceedings that could be held remotely should be held via phone or WebEx. The trial court judge said that order didn't apply to jury trials, held the lawyer in contempt, and he should be sentenced today on that contempt charge. I think it's worth noting that it appears his actions were coordinated with his office, at least based on what he said. There is a policy at the Colorado State Public Defender's Office to not hold in-person jury trials if public health data doesn't support it. And they also have a statement that courthouses and jails are unsafe working environments in light of the pandemic. So I think that case really highlights the tension between courts wanting to start moving their dockets forward and individual attorneys or perhaps parties who are uneasy about that due to safety issues. And as courts start to open up more, it'll be interesting to see if we start seeing more of these kinds of actions and how courts deal with them. But some courts around the country are proceeding on a much slower schedule. DC Federal Court has the majority of court proceedings happening remotely, although now a party can request an in-person hearing, and that's at the discretion of the trial judge if it's deemed necessary. So it remains to be seen how that standard is going to be applied, but you can start requesting in-person proceedings. Grand juries are meeting, but only on a limited schedule, and jury trials there have been suspended until at least November 9th, but that date could, of course, move again. The court there has also been kind of taking an iterative approach to reevaluating their operations on a regular basis. But all proceedings there that are happening in person include social distancing and other safety precautions. And finally, turning across the country to LA, the Central District of California courthouses are closed to the public. Civil cases are happening by phone or video, and criminal proceedings are also happening in person if the defendant doesn't consent to a phone or video. And there are no jury trials happening there, whether civil or criminal, although civil cases can proceed to bench trial if the parties are okay with the video or remote access. So setting aside kind of the in-person stuff, the motions practice is definitely alive and well across the country. So Lauren, what trends are we seeing in litigation over COVID issues?
Sure, and as you can imagine, the COVID-19 pandemic has hit jails and prisons really hard. The Bureau of Prisons has about 140,000 federal inmates in their facilities, and they actually publish a daily ticker of all the statistics on COVID-19. Most recently, I saw that they had documented 2,000 inmates who've tested positive in federal prisons. 15,000 have recovered from COVID and 128 have died. So if you do the math on that, that's approximately 12% of the federal inmate population has had COVID at some time. And that's, of course, only those who have been tested and reported it. So the number could be far higher than that. So in March, Attorney General Bill Barr issued guidance to the BOP, directing them to prioritize home confinement for nonviolent offenders who had completed more than half of their sentences at that time in light of the pandemic. And BOP is given broad discretion to consider numerous factors like age, health, chances of recidivism, et cetera, generally factors that are going to favor white-collar defendants. But there was a series of inmate deaths in the spring that got a lot of publicity, and Attorney General Bill Barr again issued some guidance in April that targeted certain prisons where there had been outbreaks in the inmate population. He directed BOP to prioritize moving inmates to home confinement from those prisons if they met certain qualifications, and he also eliminated the requirement that inmates have had to have served half of their sentence at the time. But the process gives BOP a lot of discretion to consider all these factors and determine who they recommend actually being released. So, there's been criticism in recent months, that those decisions have been very political. For example, Paul Manafort, the head of Trump's 2016 campaign, was released very early on in the spring. Michael Cohen, former personal attorney to President Trump, was released in May. We're going to talk about him for other reasons later. So BOP's gotten some flack for being political about decisions, but keep in mind that inmates have other routes to try to seek release based on the pandemic. Separate from the DOJ guidance, inmates can file what's called a compassionate release motion with the sentencing court under something called the First Step Act. And that law allows courts to reduce sentences based on, quote, extraordinary and compelling reasons. And it's been found that, of course, the pandemic has been an extraordinary and compelling reason. Obviously, inmates have had differing results. When they file these motions, they're not always granted. But a recent decision out of the Second Circuit has been really important, I think, for inmates, because it just cements the fact that sentencing courts have broad discretion under the First Step Act to determine whether these extraordinary and compelling reasons exist for a reduction in sentence. And the case there is called US v. Brooker. So this is helpful to inmates who face a situation where the BOP may not agree that they meet the certain factors to be released, gives them more power to file a motion with the sentencing court.
So since the onset of the pandemic, the U.S. Attorney's Office in the Southern District of New York has had to deal with not only pandemic-related concerns, but also they've suffered some reputational setbacks in a series of cases in recent months. They've been criticized for failing to disclose Brady material, for making political decisions. So Lauren, what else do we have to talk about there? Oh, looks like you're on mute.
Thank you, Catherine. A Zoom flaw. So yeah, thank you, Catherine. So there's been a lot of interference in the leadership and instability in the leadership in the U.S. Attorney's Office up in the Southern District. In June, Attorney General Bill Barr suddenly fired the then U.S. Attorney Jeffrey Berman. Berman did not go quietly. He initially refused to leave and said that he wouldn't leave until a nominee had been confirmed by the Senate, but he ultimately acquiesced and had to step down. So now there's an acting U.S. Attorney, Audrey Strauss, who is in place while we wait Senate confirmation of someone to replace Berman. So there's been a lot of instability and leadership issues up in the Southern District. And now we're going to talk about some of the implications of that, as well as the reputational setbacks that the Southern District of New York has faced in recent months.
Thanks, Lauren. So I want to start with a case that people may remember as one of the last white-collar cases to go to trial in SDNY before the pandemic hit. So in March, Iranian businessman Ali Sadr Hashemi was convicted of violating sanctions against Iran and fraud and money laundering charges in connection with a scheme to fund an infrastructure project in Venezuela. So the case, as I said, ended in a conviction in March, but over the next few months in post-conviction proceedings, things kind of swiftly took a turn, so that by June, then U.S. Attorney Berman filed a one-page letter with the court seeking to drop its case, and also vaguely referencing, quote, disclosure-related issues that arose during the March 2020 trial, as well as in pre- and post-trial motion practice. So subsequent to that, Judge Allison Nathan issued an order demanding detailed information from the government regarding their alleged Brady violations. And in September, she issued a frankly scathing opinion, a 34-page opinion, excoriating prosecutors for violating their Brady disclosure obligations. She concluded that the disclosure-related issues that first arose shortly after this case was transferred have, quote, disturbingly continued unabated since. So among other incidents that she walked through in this letter is one that, or this opinion is one that I want to highlight. The government had failed to disclose an exculpatory letter until trial had already begun. And the letter, as I mentioned, this is a sanctions case. The letter dealt with the first payment charged against the defendant and showed that the Office of Foreign Asset Control, OFAC, had been informed of the payment, and they had also been informed of its potential connection to an Iranian company in an effort to comply with sanctions-related requirements. So during trial, when the prosecutors realized that they had not previously disclosed the document, their error was compounded by a series of internal chats that have since come to light among prosecutors discussing burying the exhibit in a larger disclosure, and ultimately they produced the document in an exhibit that the court described as deliberately obscuring the fact that the exhibit had not been previously produced. The prosecutors wound up sending an email to defense counsel, starting out by talking about an issue with a trial witness and then listing a number of documents. This letter was one of those documents, and the letter was not specifically called out as not having been previously produced. So in light of that and other issues, the court concluded that the issues at this trial that plagued the prosecution in that case, quote, call for systemic solutions. And so as part of that, she ordered all prosecutors in SDNY to read her opinion within the next week. And she also recommended referring the case to the DOJ's Office of Professional Responsibility for investigation. Lauren, I understand there's another noteworthy case that you alluded to earlier in the SDNY that raises concerns about prosecutors' conduct, this time in a more political fashion. So what can you tell us about the Cohen case?
Yeah, so I want to talk about the Cohen case. Our favorite Michael Cohen, who is President Trump's former personal attorney, as you probably know, was serving a 3-year sentence up in New York for tax evasion and campaign finance related violations related to his dealings with President Trump. And in May, he was released from prison to home confinement due to the pandemic. Well, following his release, he announced in the press, as you probably remember, that he was going to write this tell-all book about President Trump. And then when he reported for what was supposed to be a routine appointment with the US Probation Office in July, probation officers presented him with what his lawyers say appeared to be a customized agreement for the terms of his release. It did not look to be a standard terms of release agreement. And so according to his attorneys, he was presented with this agreement. It had this very strange provision in it that prohibited him from engaging with the press or using social media at all, which effectively would have prevented him from publishing his book. So he was there at the probation office for several hours that day. Apparently there was a lot of discussion among the attorneys. There was a lot of waiting around, and then eventually, Cohen didn't sign the agreement, but he was actually handcuffed and taken away and told that he was going back to jail because he hadn't signed the agreement. And in a very unusual move, the Bureau of Prisons doesn't usually publicize things or put out press releases, but they said that Cohen was taken into custody because he failed to agree to this agreement that he had been presented. So following his being put back in jail, and he was actually in solitary confinement, Cohen's attorneys filed a motion for a temporary restraining order. And they argued that he should be released because the BOP was violating his First Amendment rights. So the US Attorney's Office objected to the TRO. They said that Cohen had been very antagonistic during his meeting with the probation office, that he took issue with nearly every provision in the agreement. And, essentially it was his fault and the agreement was kosher. So that's kind of where it went. And then Judge Alvin Hellerstein, who is the presiding judge, sided with Cohen in this issue and swiftly granted the TRO. The court found that the purpose of Cohen's transfer back to jail was retaliatory, and it was because of Cohen's desire to write a book and exercise his First Amendment rights. What I think was really fascinating about this case was what the judge said in court, and he said to prosecutors that he had never seen such a gag order in his 21 years on the bench. Judge Hellerstein ordered Cohen to be released the next day, and he was. And then he also enjoined the government from future retaliation against Cohen for exercising his First Amendment rights. So fascinating case. This one was one that involved more politics and retaliatory tactics as opposed to the issue of failure to release Brady evidence. But again, another troubling development out of the Southern District of New York. So Katherine, are there any other cases that you want to report on that have the potential to further harm the Southern District of New York's reputation?
Sure. So this next case is one that's still in progress. So, you know, there's no ruling yet, but I think it's worth noting that the judge is really taking these Brady issues seriously. So in July, Judge Catherine Pope-Fela demanded information from the government following an assertion from defense counsel that they had obtained potentially exculpatory material through a FOIA request after the trial and after the conviction. So backing up a little bit, there was a 6-week trial last year. The former CEO of hedge fund Premium Point Investments, Analasha Ahuja, was convicted of fraudulently inflating the value of his firm by $100 million. And at trial, the government relied on a number of cooperating witnesses, one of whom was a former portfolio manager, Amin Majidi, who pled guilty to participating in the scheme. So prior to trial, the defense filed a subpoena to get documents from Majidi related to his plea allocution. And Ahuja's attorneys argue that prosecutors only turned over a draft plea allocution during trial when they found out that Majidi intended to produce the document in response to the subpoena. And it's notable that they only made a disclosure 2 days into trial. And according to defense counsel, under their reading, the plea allocution draft differed significantly in key respects from the plea as delivered. So the court declined to dismiss the indictment during trial, but did order the government to turn over all disclosable information. And following his conviction, as I mentioned earlier, Ahuja's attorneys filed a FOIA request to the U.S. Attorney's Office, and they obtained additional documents this summer. Based on their filings with the court ordered the government to run additional searches, produce additional documents, and indicated that she's going to hold an evidentiary hearing on these issues. So since that ruling in July, there's been a bunch of back and forth on the docket about the discovery process. And as recently as last week, the judge ordered the government to provide additional information regarding remaining deficiencies in their productions. And she indicated that she was not going to schedule a hearing until the government's production is complete. So it remains to be seen how this one is going to end, but I think it's worth noting that the court is taking it very seriously, especially in the wake of that 34-page opinion from last month.
Fascinating. Yeah, all very interesting cases. So I think, what does this all mean for the Southern District of New York? I think there are a few takeaways. First of all, we have an acting U.S. attorney currently in place in the SDNY. So we'll have to follow to see whether she takes to heart this series of rebukes against her prosecutors and will implement new training for line prosecutors. And also whether she will actually refer the Sadr case to the Office of Professional Responsibility as Judge Nathan recommended. At a minimum, all of the AUSAs in the Southern District of New York are required to read this 34-page opinion, and hopefully they will take it to heart and use it as an opportunity to remind themselves of their Brady obligations. And another thing I think to keep in mind is, while courts are opening up in different capacities across the country, and Katherine, you touched on how disparate this is, a lot of people still are working from home and not having direct contact with prosecutors as their cases progress. So they're not having in-person contact, they're not maybe picking up the phone as much. And so because of that distance, I think for defense attorneys, we really need to be on guard. We really need to be engaged with prosecutors to ensure that they are fulfilling their Brady obligations and turning over their investigative files when they're supposed to, and as fulsomely as they are supposed to. So those are my just immediate thoughts on the situation in the Southern District of New York.
Yeah, and I think things are definitely evolving, and you know, SDNY has these trials going forward, so there's a lot of movement in courts right now. And on that note, we can move on to some noteworthy indictments and guilty pleas of executives in recent months. As Lauren just noted, you know, investigations are starting to heat up. Grand juries are sitting. We're seeing more charges in recent months than we were early on. So what trends are we seeing in cartel enforcement?
In cartel enforcement, so this is my area of specialty, so I like to follow the trends where I can. So what I think we're seeing in recent months since March, and things have in some ways stabilized, or we've come up with a new normal with COVID, is that there has been an uptick in charges against both executives and companies in recent months in cartel enforcement. And I've seen it largely in two areas. One is the generic drug investigation, which has been ongoing for some time, and one is the newer chicken broiler investigation. Let's take the generic drug investigation first. 3 pharmaceutical companies were charged this summer with allegedly colluding to fix prices on certain generic drugs. And those companies are Taro, Teva, and Glenmark. 7 companies have been charged total in the investigation, and 4 individuals have been charged, 3 of whom have pled guilty. So what's interesting about these recent charges against the companies is that it marks the first time that DOJ has indicted a company in the generic drug investigation rather than resolving the case by DPA, so deferred prosecution agreement. Under a DPA, charges are entered but not prosecuted unless the company doesn't fulfill the requirements of the agreement. So assuming the company does so, fulfills the requirements, which usually are related to remediation, then the charges are ultimately withdrawn. So in this case, both Glenmark and Teva were indicted this summer. And that's the first time we've seen that in the investigation. There's speculation amongst the defense bar that DOJ pressured these 2 companies to plead guilty, and when they felt, for whatever reason, that that was not the appropriate resolution of the cases, DOJ wanted to send them a message and indicted them to show that they really mean business. So what's also interesting about the developments in the generic drug investigation is that none of the 7 corporate resolutions has been by guilty plea. In cartel investigations, typically the antitrust division resolves criminal antitrust charges by guilty plea unless there is a leniency applicant who qualifies for leniency and ultimately avoids charges altogether. Up until recently, the antitrust division has resisted resolving criminal cases by DPA, unlike, for example, the fraud section, because of the concerns that it might undermine the leniency program. But in July of 2019, the antitrust division changed its policy. They announced they would consider resolving cases by DPA where a company has demonstrated the 4 hallmarks of good corporate citizenship, as they call it. And those hallmarks are having an effective compliance program, self-reporting the wrongdoing, cooperating with the government, and remedying the past misconduct. So it's unclear whether these DPAs will continue within the generic drug investigation and also beyond the generic drug investigation, and whether they will become the new norm for resolving criminal antitrust cases.
And I think you also mentioned that there had been some developments in the broiler chicken investigation. And as we approach lunch, I don't know if that's appetizing or not for folks, but why don't you tell us about that?
Yeah, I promise not to get into any rendering processes or anything like that. Yeah, so this is a relatively new criminal investigation, but not a new case. So the broiler chicken investigation is unique because it actually stems from a civil class action that was filed in the Northern District of Illinois in 2016. Typically, the criminal investigations precede the civil class actions. But here, DOJ moved to intervene in the civil class action in June 2019, and that was, I think, the first time that it was publicly disclosed that this investigation was going on. In June of this year, a Colorado federal grand jury indicted 4 current and former executives of 2 major chicken companies, including the CEO of Pilgrim's Pride. And it's pretty unusual for the antitrust division to be able to indict a CEO. We'll talk about one other case that recently occurred in the canned tuna industry, but being able to indict a CEO is obviously going after a big fish for the antitrust division. And DOJ alleges that from 2012 to 2017, the 4 executives colluded to manipulate the price of chicken broilers sold at food joints as well as food distribution centers in the US. In October of this year, Pilgrim's Pride pled guilty. It's the first company to do so, to its involvement in the conspiracy, and also agreed to pay a $110 million fine. Separately that month, DOJ indicted 6 more individuals in the investigation and brought a superseding indictment against one of the original individuals to be indicted, this time allegedly for making false statements. So this brings to 10 the number of individuals who've been charged as part of this investigation. As far as I understand, all of them are fighting the charges at this point, and no one has pled guilty. So we'll see how this investigation proceeds and whether or not we'll see additional indictments in the coming months.
So kind of setting aside these 2 investigations, the generic drug and the chicken broiler, what other kind of trends are you seeing in cartel cases?
Sure. So as I mentioned, I think we're generally seeing an uptick in charges against both companies and individuals since COVID began. In the first few months, there was very little movement. But one thing to note is these charges are largely domestic. For example, generic drugs and chicken, those both relate to conduct in the United States. And they also involve localized conspiracies. So, for example, bid rigging of local contracts. In fact, we saw just the other day that a North Carolina engineering firm was indicted for allegedly bid rigging of Department of Transportation contracts with the North Carolina state government. So we're seeing national and localized investigations that are occurring as opposed to the big cross-border investigations that we had seen in the past. And that's a trend, frankly, that has continued over the past few years. The auto parts investigation was the largest in the antitrust division's history and came to an end, I'd say, sometime around 2015. It was about 2010 to 2015. And nothing has really replaced it on the scale that the auto parts investigation was. And we also haven't really seen a cross-border investigation of the scale of the auto parts investigation. So those are some of the trends we're seeing. We're also seeing that charges generally are not coming out of these big leniency-driven cases. I mentioned, the case that started because there was a civil class action first. That's one example of how investigations are starting now that are not sort of the traditional leniency-driven investigation, which tends to lead to a bigger investigation, potentially more cross-border conduct involved. So that's kind of my take on where cartel investigations are these days. What are you seeing on the FCPA front?
Yeah, so I think, as we mentioned earlier, investigations continue to move forward, settlements continue to happen, and I think the Herbalife settlement from this summer offers a few lessons for where the priorities are in terms of compliance programs right now. So in August, Herbalife, which is a multinational nutrition company, entered into a settlement with both SEC and DOJ for a total of $123 million to resolve FCPA accounting violation charges. And the settlement came just a couple months after the DOJ had updated its evaluation of corporate compliance programs guidance. And the Herbalife DBA really reflects some of those changes. So this is a little inside baseball maybe, but the DOJ traditionally sets out its minimum expectations for compliance programs in Attachment C to their deferred prosecution agreements. And the Herbalife Attachment C contains a few updates that bring it in line with the updated compliance program guidance that the DOJ issued over the summer. So to highlight just a few points that I think are salient for executives, the first is that there's now more of an emphasis on not just a high-level commitment from executives and from the company writ large, but also an emphasis on tone from middle management and tone across the company for compliance. In addition, Attachment C now emphasizes the importance of ensuring that compliance personnel have access to all the data that they need for their monitoring and testing activities. And Attachment C now also emphasizes the need for risk-based assessment and due diligence on third parties. And aside from kind of the compliance program focused issues, I think it's also of note that at least to date, only 2 Chinese level executives have been indicted in connection with the Herbalife investigation, and we have not seen charges against any American executives. I think it's also of note that Herbalife avoided any bribery charges in this case, instead resolving accounting violations. And in doing that, they also avoided the appointment of a monitor. And so the company has agreed to submit reports itself on its remediation efforts and its policies and procedures improvements over time. So, so that's where FCPA enforcement stands right now. Lauren, what other cross-border issues are we seeing?
Sure, I want to talk about a couple of extradition cases in recent months, and these are important for executives to keep in mind because generally speaking, we've seen investigations become more cross-border over the past decade or so, so it's always important to keep extraterritoriality issues in mind. So the first case involves a businessman named Alex Saab. In July, a court in the island country of Cape Verde approved the extradition of Alex Saab to the US. He's a Colombian national who allegedly has ties to Venezuelan leader Nicolas Maduro. He had been indicted in the Southern District of Florida on money laundering charges related to bribes he allegedly paid Venezuelan officials, and this was in connection with a housing project. He was arrested in Cape Verde on a layover and in response to a red notice that was issued by Interpol. For those who are unfamiliar with Interpol, it's an international organization that facilitates worldwide law enforcement cooperation. So a red notice is a request by Interpol to its member countries to assist in locating or arresting individuals. And so the court in Cape Verde has ordered Mr. Saab to be extradited back to the US. As far as I know, he has not been sent back to the US. I think he's still there, but we'll continue to follow that in the press. Separate from the charges that were brought against him by the Southern District of Florida back in July of 2019, Saab was sanctioned by the US government for allegedly using shell companies to hide profits from overvalued food contracts that he allegedly obtained through bribes and kickbacks. So remains to be seen what's going to happen with Alex Saab, but he should be returned to the United States at some point to face the charges. The second case that's interesting and relates to extradition involves an Iranian national from the UK who was extradited on charges that he defrauded the US government and violated Iran's sanctions. The executive's name is Syed Sajjad Shahidian, and he was the CEO of a financial services company called Payment 24. And it's a company that had offices in Iran. He, along with the former COO of the company, was indicted under seal in December of 2018 for allegedly exporting computer software, computer licenses, and computer services to Iran in violation of sanctions laws. He was arrested in the UK in November of 2018, and in May of this year, a UK court agreed to extradite him to the US. He was subsequently extradited, and he ultimately pled guilty and admitted to assisting hundreds of Iranian clients with making illegal online purchases from US-based businesses. Most recently, just this month, he was sentenced, and he received a jail term of just under 2 years. The former COO, however, who was also indicted, still remains at large.
Really interesting. So let's talk about another few sentencings that have happened over recent months, starting with the tuna investigation that you mentioned earlier.
Yeah, this is an interesting case. So as I mentioned, it's rare when the antitrust division is able to charge and actually get the successful conviction of a CEO of a company. That's a big fish for DOJ. So in June, the former CEO of Bumblebee, the canned tuna company, was sentenced to 40 months in prison after a jury found him guilty of engaging in a 3-year conspiracy to fix the prices of canned tuna. During trial, 3 other individuals who pled guilty to participating in the scheme testified against him. The case is noteworthy for a couple of different reasons. First, it's unusual for a CEO, for any individual, frankly, in a cartel case, to decide to go to trial. And the vast majority of individuals charged in these cases plead guilty, and typically their sentences tend to range around the 1.5 years, sometimes even less than that, in prison. The Antitrust Division typically agrees to resolve guilty pleas under Rule 11C1C of the Federal Rules of Criminal Procedure, and that allows the government and the individual to essentially agree to a jail term in the guilty plea. It gives the judge very little power to change the sentence. And I think that gives some cartel defendants comfort and ultimately influences their decision whether or not to plead guilty. But here the executive gambled and went to trial. And when he was found guilty, the court had more leeway to set his sentence. The 40-month sentence is based in large part, actually, on the volume of affected commerce. And the judge determined that the volume affected commerce for this case was $600 million. The sentence was well below what the prosecutors wanted, which was 8 to 10 years, but obviously nowhere near what the defendant wanted, which was home confinement. And aside from the CEO's decision to go to trial, the case is also unusual in terms of how it was originated. I was talking earlier about this trend away from these big leniency-driven cases and how some of these other cases have been initiated through kind of different means, not the typical leniency applicant. Here, the case came about after 2 canned tuna companies, Bumblebee and Thai Union Group, which owns Chicken of the Sea, filed papers with DOJ to go through the merger process. DOJ found that the merger was anti-competitive and ultimately blocked it from going forward. But during the merger review process, DOJ lawyers found evidence of collusion among competitors in the canned tuna industry to fix prices and turned that evidence over to their counterparts in the criminal enforcement section of the Antitrust Division. So this ultimately sparked a criminal investigation, and Chicken of the Sea was given immunity, thus avoiding prosecution. Bumblebee and the rival company Starcrest both pled guilty. Bumblebee was forced to pay a $25 million fine, and Starcrest paid a $100 million fine. There were 4 individuals who were charged in the investigation, and 3 of them pled guilty, and the one who did not was the CEO who went to trial. So a very interesting case, not just from the perspective of the sentencing, but also how it originated. Katherine, I think you have an interesting case you want to talk to everyone about that involves interesting loss calculations. What's that?
Yeah, so as our white collar practitioner colleagues who've joined us today know, loss calculation is such a crucial part of determining the sentencing guidelines range. And so I wanted to take a moment to focus on a sentencing in May out of the Eastern District of New York in US v. Kiriakou. The Eastern District of New York Judge Kiyo Matsumoto sentenced the former investment manager of a UK brokerage firm to 3 years of probation with no prison time. And what I think is notable there is that the government had sought to use some statements made by an undercover agent to the defendant in order to calculate the loss. So the government had said that the defendant had the intent to cause millions of dollars in losses based on, again, statements that an agent had made during conversations during the scheme. And so if the judge had bought that argument, that would have been a 16-level enhancement, which would have significantly increased the potential guidelines range. Would have been 37 to 46 months in prison. Without that enhancement, it would have been 0 to 6 months. So I think the case is notable just that it really highlights the importance of those loss calculations. And also notable, I think, to see the government pointing to statements that are not from the defendant as informing their view of the loss calculation. So again, the judge went without the enhancement, and at the bottom end of that range, no time in prison and 3 years of probation. So I'll turn it back to Lauren to wrap up. And as a reminder to everybody, you can email events@milshev.com if you have any questions.
Thanks, Catherine. So I think we've kind of come full circle here because you were talking earlier about the Sadr case, which I think was the last white collar case in the Southern District of New York to go to trial, and the repercussions of that due to the prosecutor's failure to turn over Brady evidence. And now we're at the point where we're seeing courtrooms open up and the first case proceed. And as you mentioned earlier, it sounds like there really is a lot of disparity across the country in terms of how courts are proceeding. Some are occurring in person and some are not. So I think it's interesting as we move forward, especially as defense attorneys, that we really need to be on guard in protecting our clients, ensuring that prosecutors turn over the Brady evidence that they are supposed to, because things are still not normal. It's sort of the new norm with COVID, but there's so much disparate behavior going on across the country and across courthouses. I also wanted to, Catherine, your interesting take in the beginning on courthouses made me think a little bit about access to courts. And I wanted to ask you, what is going on that you're hearing about access for the public as well as the media, and whether they are able to attend by phone or attend in person all of these court proceedings that are starting up again?
Yeah, I mean, like I mentioned earlier, it is such a mix of outcomes because you've got basically every district court, every circuit court, every state court coming up with different ways to make it through this pandemic safely, but keep operations running. So as I noted earlier, federal court in LA, the website specifically says it's closed to the public. A lot of courts have ways for people to call into proceedings, but those, I think, are being applied differently across the country. So you've got some courts where the press and just members of the public are allowed to dial in, but there are questions around whether or not you have to identify yourself on whether it's a Zoom call or by phone. If you're there, if you have to announce yourself, that's something that you generally don't have to do if you're just going into a courtroom physically. Some courts are prioritizing for proceedings that are happening in person, press access. Some of them are not and are having the press either be in other rooms with it streaming or not attend in the physical courtroom. Here in DC and Superior Court, at the beginning of the pandemic, while things were getting underway, you had the clerks asking people to identify themselves by phone number on the line, so reading aloud phone numbers into the record, and so that raised privacy concerns. And I think that practice has been stopped now, where they won't read your whole phone number into the record. So I think it's a real point to watch. And as we move forward, if we see more people like that case out of Colorado trying to litigate issues around whether they have to be there in person, it remains to be seen. Are we going to see any actions by the press or by members of the public in terms of making sure that they get access to the courts as they would if we were all there physically? So definitely a lot of different streams to keep track of as we move forward.
Very interesting. Thank you, Catherine. So I don't think that we have any questions from the audience at this point. So I think that's all we have for you today, unless there are any remaining questions. We'll give it a minute. But we want to thank you for joining us, and we're hoping to do this regularly in the future. We encourage you to read our Executives at Risk newsletter, which we publish quarterly, and we're hoping that we can continue this webinar after we publish each of the quarterly publications. Okay, thank you everyone for listening in.
Thanks everyone.